Ms. Jankaitis?
Jankaitis. Thank you, Your Honor. This is Kelly Jankaitis appearing for Aaron Ludwig and Andrew Meyer.
Thank you, and good morning to all. This is a hearing on a number of motions to dismiss. It's the I'm just looking at it's the renewed motion to dismiss filed by Defendant York, the motion to dismiss filed by Defendant DeSalles, the motion to dismiss filed by Defendants Doolin and Travis, the renewed motion to dismiss filed by Defendants Degnan, Horn, Langtree, the first motion to strike filed by Defendants Degnan, Horn, and Langtree, and a second motion to strike filed by Defendants Doolin and Travis, along with Defendant Ailstock's notice of joinder, plaintiff's notice of renewal and adoption of prior oppositions as to the second amended complaint, and Mr. Ludwig and Mr. Myers joinder. Did I hit all the pending filings?
Yes.
Okay. So this is because there are a large number of defendants. The court just wants kind of the parties to the defendants to provide just brief kind of arguments, 2 to 3 minutes of what the parties believe the court should look out for. Alternatively, what I've seen in these large defendant cases is that a certain defendant is designated to speak on behalf of all the defendants. I didn't know if the defendants had an opportunity to discuss that, or if they wish to have 3 minutes and change each, and about a minute or two on rebuttal. Is there any consensus there?
Your Honor, we have not spoken ahead of time. 3 minutes is fine for me, Your Honor.
Same for Your Honor.
Very well. So I'll give each defendant or group of defendants approximately 3 minutes each. Plaintiff will then have 20 minutes, and then there will be about a minute each for the defendants to have a rebuttal. So anything else to take up before we begin? I heard Ms. Carr indicated nothing. Anything from the defendants?
There you go.
All right, Mr. York, if you could begin.
Your Honor, I just wish to make a very brief statement, which is that plaintiff's pleadings do not constitute a coherent cause of action and therefore should be dismissed. And I reiterate all the arguments I've made in my previous pleadings, and I concur with all the arguments made by the other defendants in this case. And that's all I have to say on this matter, Your Honor.
Thank you, counsel. Mr. Ailstock.
Good morning, Your Honor. I have a procedural question, Your Honor, which is what I have filed thus far in the case is a notice of joinder to Mr. DeSalles and the Degnans motion to dismiss. This was in March before the ruling. The minute entries for a certain direction on filing either renewed motions or notices was always directed at the folks who had subsequent filings and the appearing defendants. And so I have intentionally been waiting and watching the motions and reviewing them and the responses with the intent to file my motion to dismiss, which is also what's stated in my original joinder. But I spoke with Ms. Carr for a potential good faith consultation, and she took the position that I could not file a motion to dismiss at this time. And so I did want to ask the court, I perhaps could have read your minute entry too intentionally when it was referring to the appearing defendants. I haven't yet filed a Rule 12 motion or responsive pleading, but I will. I can do it immediately. But I wanted to clarify with the court that with the number of filings that were at issue in the minute entries and some of the dates that were provided, it wasn't directed at myself as I took it, as I hadn't been an appearing defendant yet through either a motion to dismiss or a responsive pleading. And so what I wanted to request from the court is I'll file my motion to dismiss here immediately, but wanted to confirm that I was correctly reading the court's minute entry. And if I did not, I apologize. I suppose maybe I read it too literally.
So just to be clear, Mr. Ailstock, there's no joinder. You don't have a currently pending joinder or a currently pending motion. Is that correct?
That's correct. I have not filed a Rule 12 motion or responsive pleading yet. So the kind of the litany of filings that the court was referencing in the minute entries, setting up the time for oral argument, it was always a reference to the appearing defendants. And I took myself as not yet an appearing defendant for the reasons that I stated. I've been reviewing the filings and the responses with the intent to file my motion to dismiss that I can file immediately, and I won't request any oral argument for it.
Understood. And the court won't kind of prejudge anything that you intend to file or any response that you intend to file to Mr. Ailstock's filing, and the court can make a determination after whatever briefing is whatever filing is made, Mr. Ailstock. So the court won't, any ruling today will not not necessarily touch upon Mr. Ailstock, because Mr. Ailstock is not joined or moved to dismiss, because he's anticipating filing a separate motion to dismiss. Anything further, Mr. Ailstock?
No, sir. Thank you.
Mr. Zazuta.
Thank you, Your Honor. My client's filed a motion to strike, and it's related to the plaintiff's response to the motion to dismiss. I guess before I begin, I want to either get a ruling on the motion to strike because it exceeds the response exceeds the page limits by 6 pages, and also there are 2 exhibits attached to the response that are neither central to the plaintiff's claims or public record. So that's all I'll say on that point, Your Honor. I just wanted to make that clear that there is a motion to strike there. Your Honor, I'm not going to belabor the points because I suspect the court's going to hear repeated arguments or the same arguments from a lot of counsel. But I think the main fundamental question here is whether or not this plaintiff has their standing to sue and or bring a claim derivatively on behalf of her LLC. Plaintiff is aware from prior cases on at least 6 times where judges admonished her regarding her bringing claims on behalf of the LLC, and Arizona does not permit that, Your Honor, as the court is well aware. And this is the Ramada case. In this case, the initial complaint alleged claims on behalf of the LLC. The first amended complaint doesn't fare any better. It says that the claims are personal to herself, to Ms. Carr, but when you really dig into the allegations, these are claims that she brought on behalf of the LLC, with the exception of the intentional infliction of emotional distress claim. And that claim fails for 2 reasons. Your Honor, there is no physical manifestation of physical injury that she alleges, the plaintiff, and the doctor, with all due respect to the plaintiff. The second thing is that there's no causal connection pled that because of this alleged conduct, she suffered damages. So those are 2 elements those are the 2 factors from the 4-factor test for an IIED claim, which is not pled in this case. And at the end of the day, Your Honor, this is a case where she is dissatisfied with her counsel. I know a lot of counsel here, and they're all respected counsel. It's just a matter of she is dissatisfied with the result of litigation, and that's it, Your Honor. I think that's 2 minutes, 3 minutes, but unless the court has any questions, I'll pass to my other colleagues here who may reiterate some of the things I have already said.
Thank you, counsel. Mr. DeSalles.
Thank you, Your Honor. I agree with everything Mr. Zazueta just said. I would incorporate that to myself as well. What I want to address and I'll take about 60 seconds perhaps, is just the incongruity of the nature of a conspiracy theory. In this case, everyone that came before me conspired to prevent the filing of a treble damages claim. That was the conspiracy, or at least that's part of the conspiracy. I filed that motion, and I'm also part of the conspiracy not to file the motion. At its very basic core, like most conspiracy theories, it collapses because the facts don't make any sense. The law, as Mr. Zazueta said, doesn't make any sense either. I'm happy to defer. Unless Your Honor has any questions, I'll save what I have for rebuttal.
Thank you, Mr. DeSalles. Ms. Doolin.
Thank you, Your Honor. We also have a motion to strike portions of a response filed by Ms. Carr. She is responding to a motion filed by Mr. Zazueta's firm but then makes unsubstantiated allegations as to our firm. So just pointing that out for the record. Again, I join in my colleagues in urging the court to dismiss this case. You know, Ms. Carr lacks standing to bring this case. All of her allegations relate to her LLC. We know the LLC is a separate person under the law. She hasn't alleged any factual claims against herself personally. They all relate to this foreclosure case filed by the association against the LLC. They were never against her. Same thing with these so-called agreements reached with her counsel. You know, she's not alleging anything against her personally, Your Honor. So unless you have any questions, I defer.
Thank you, counsel, and Ms. Jankaitis.
Thank you, Your Honor. My clients, Meyer and Ludwig, are similarly situated to the other defendants here in this case as former counsel for the LLC that was the subject of the underlying litigation. And our joinder, I think, was specifically to one of the motions to dismiss, but we join in all of the arguments that were made today because they all apply equally to these defendants, and ask the court to dismiss the case with prejudice for the reasons that have already been stated.
Thank you. And I think that everyone has had an opportunity to speak on behalf of the defendants. And there's still some additional time. If anything has occurred to any of the defendants, the court will allow that those statements to be made by any of the defendants. Otherwise, the court can consider the time to be reserved for rebuttal. So is there anything further that the defendants wish to offer, or instead do the defendants wish to reserve the rest of their time for rebuttal?
I wish to reserve my time for rebuttal, Your Honor.
Same.
Your Honor, I want to make a point here in that on a 12B6 motion, the case law suggests that the court can give leave to amend. To the extent the court is inclined to do so, I'm happy to address any reasons why the Owen factors preclude any further amendment.
This would be the time to present those arguments.
Your Honor, the biggest and most one is that this is going to be futile if the court gives leave to amend for the plaintiff. A lot of the claims, if not all the claims pled here, again, are on behalf of the LLC, and any claim that the court can derive from that is personal to the plaintiff, they just fundamentally fail on their face, and that the facts just don't fit the elements of these claims. So any further amendment would be futile. And for those reasons, to the extent the court is inclined to grant leave, it should not do so for the reasons stated.
Thank you. Anyone else on behalf of defendants before I go over to Ms. Carr and then and provide the remaining time as rebuttal? Hearing nothing, I'll then pivot over to Ms. Carr. Ms. Carr, thank you for your patience, and I wanted to hear from you on your position as to the motion to dismiss.
Sure. Your Honor, these are my personal claims that were intentionally inflicted on me because I was their target. They wanted to suppress my whistleblowing action against their misconducts. And the underlying association, ASCUDA, has caused so much unsafe plaza conditions where one of my patients literally almost died from it. And the city of Glendale gave them a lot of civil and criminal citations. And it took them almost 2 years to bring all those violations to compliance. 2 of my patients submitted their own affidavit to the court stating that they literally narrowly escaped death because of unsafe plaza conditions. And this was happening because the plaza, ASCUDA, was using the money for their own personal use, alleged misappropriation of the funds or embezzlement. And I was a whistleblower. So when I started creating this noise against them, they intentionally targeted me. They put my medical office condominium in fabricated foreclosure claim because they knew it would stress me, distress me. So these are my personal injury claims. And one of the case that Zezueta has mentioned and cited in this case few times, it's a parallel case going on in this court itself. And the case number is CV 2026-00016 that I have filed against ASCUDA, and intentional infliction of emotional distress in that case has survived motion to dismiss. and that case is pursuing further. So this infliction of emotional distress was real, to the point that I literally had to stop focusing on my medical care, stop taking new patients in my medical practice so that I can join law school and study law. I'm a second-year law school student right now. I studied law. I have been studying law for 7 hours every day. In Arizona, I'm an endocrinologist. The current way to see endocrinologist is 9 to 12 months. And I stopped taking new patients so that I can focus on law, because all these attorneys that I hired to represent me, they colluded with opposing counsels. And there's a factual allegations in second amended complaint, which taken true at this point and construed in the light most favorable to me. Does state claim for civil conspiracy? Does state claims of fraud? Does state claim for aiding and abetting by my own counsels with the opposing counsel in the underlying action? Does state the claim for breach of fiduciary duties? And does state the claim for intentional infliction of emotional distress? I pursued the fabricated foreclosure claim was placed on my property in March. I begged my own counsels to get it withdrawn. They did not. I went to federal court myself. Back then, I was not an attorney. So I thought this should be covered under Whistleblower Protection Act of federal law and unfair deceptive acts and practices. The federal court issued 7-page long judgment against Escuda, stating that they did not contest those allegations, that they intentionally created a distress and emotional pain and suffering for me so that they can suppress my whistleblowing action, can suppress my my voice against them, and can continue on with their financial misconduct. The Arizona law mandates these associations to provide those financial transparency within 10 days of being asked. I have been asking that for 5+ years. Even in the underlying action, the case went on for over 2 years. They still did not provide those financial transparencies. After the case was dismissed without prejudice, the underlying action, because none of these attorneys did anything at all, to the point none of them even submitted scheduling order at all for 2+ years. So which means they did not even have the intent to even work, because there was no working order. They were just colluding, and there is a written pleadings submitted in the underlying action by Doolin confirming that she was making arrangements and agreements with my own counsels not to pursue these relief efforts for me. And they colluded to aid and abet and enable Doolin and Travis and Escuda to continue to inflict emotional distress on me. So these are not my LLC claims. I have enumerated a lot of LLC claims, which include slandering of my title of my LLC. I'm the sole manager and the sole member of that LLC. They not only fabricated foreclosure claim against my medical office condominium, they recorded in the Maricopa County Recorder Office. Slandering of the title, and I was not able to even rent my property, which made me lose $100,000 a year. Treble damage claim coming out of this fabricated foreclosure claim. There are a lot of LLC claims that I have enumerated in my second amended complaint. It's under Roman numeral number 5, factual allegations, section A, LLC claims. There is a huge list of LLC claims. In this second amended complaint, or in this case, I'm alleging only my personal injury claims. I've suffered emotional distress every single day. It's ongoing. Even currently, until to date, Escuda is fabricating balance on my account and putting a constant threat of foreclosure of my medical office condominium. Where I should be focusing on my medical practice, I'm forced to start law school. And my law school is, in fact, much harder than regular law school, because they only graduate 5% of their graduates, the kids who enter. They fail 80% in first year. So I survived first year because I studied 7 hours every day and every day of the weekend. So these are not my LLC claims. These are my emotional suffering claims that has already survived in the parallel action, which is ongoing in this court. And Judge McDowell is the judge on that case. And Mr. Zazueta has cited, in fact, that case repeatedly in this in his motions to dismiss. And my intentional infliction of emotional distress, which is my personal claim, has survived motion to dismiss in that case. And coming back to Zazueta's motion to strike my exhibits, he is the one who started putting a lot of exhibits in his pleadings or in his oppositions. I added my exhibits to rebut his exhibits because he was saying he's not aware of any factual allegations against these attorneys. And I'm not sure if he's not reading it, the Roman numeral number 6, where I have listed defendants' specific allegations about each of these 10 defendants. He still, in his motion to dismiss, continues to state that he is not aware of any factual allegation written in the second amended complaint, when there's literally pages and pages with real proof also, with evidence in the underlying action, because underlying action is the proof in this case, and everything is on the docket listed in that case. So he is very aware of that, but he continues to state, I'm not aware of any factual allegations written against these defendants, when there is everything written in second amended complaint. So second amended complaint, well-pleaded allegations taken true at this point and construed in the light most favorable to me, states my personal injury claims. So I would respectfully request the court to deny their motions to dismiss. And recently, just 3-4 days ago, news came out in multiple news portals that the foreclosure claim by the Homeowners Association has taken a sharp increase. And over 50% of the foreclosure claims are happening only in just 5 states, and Arizona is one of them. And the reason for these foreclosure is not because their cost has gone up for landscaping, it's because they are taking the money in their own pockets. And that's the one of the claim I'm also planning to pursue separately, because after I received those financial records from the underlying Homeowners Association, SCUDA, for the last 5 years, Doolan provided me those records. Me and my staff member, we did diligently all the calculations, and they're embezzling in the amount of $70,000 to $100,000 a year. And that's the reason foreclosures are going up, not because the cost is going up, because there's no transparency. They have no liabilities. They don't even have operating license. You raise a voice against them, they fabricate balance against you, and all they have to fabricate is little over $1,200, and they can foreclose your property for little over $1,200. They have given permission, the SCUDA has given permission to all of my other unit owners around me that they can do direct deposit from their bank, which is called ACH deposit. I'm the only one who has been declined that permission because I am forced to give them manual check, which goes in the mail. Sometimes they have not even applied it to my account for over 4 months. And then they create their fees, late fees, and they fabricate foreclosure, fabricate the balance to meet the foreclosure standard. So I have the news articles also posted in New York Post, other many reputable channels, that the foreclosures are going up. In the interest of public policy and the interest of the justice, their motions to dismiss should be denied, because I have long list of LLC claims which I'm not bringing, but these are my personal injury claims. And there's a petition also to the Supreme Court that was filed in 2018 by judge of this Maricopa Superior Court, Judge David Gass, who eventually became the judge of Court of Appeal. He petitioned Supreme Court that this policy where single member, sole member LLCs and corporations have to be represented by attorneys should be abolished. He then took another alternate petition where the Supreme Court granted that in Arizona, paraprofessionals can represent, instead of attorneys, these small associations and small corporations. So he won some, he didn't win all. Then there are recent petitions filed in July of this year to the Supreme Court that these issues where small LLCs cannot be represented by themselves, single member, should be abolished, because there is huge amount of evidence that there's a growing amount of corruption in attorneys. Their focus have shifted from justice to business, and this case is a very clear example of that. I filed case for one small thing to get financial transparency from Escuda and make the plaza conditions safe. And by law, they are supposed to give me that financial transparency within 10 days. And the case, I hired the first attorney in April of 2023, and the case was dismissed without prejudice in 2025, December. And after that, the Doolan filed attorney award also by fabricating the information that I refuse mediation with them. I have in writing from my first counsel that the Doolan refused mediation. Just based on that, she asked for all the attorney fees, and she was granted because there was nobody to oppose her. Whatever she was asking, she was getting. And then she fabricated court documents, which I've also filed in second amended complaint, which she has not objected to. She fabricated court documents. She fabricated writ of garnishment. She fabricated garnish's response. She fabricated court hearing set. She fabricated notice to the debtor of the garnishment. And then she served it on my personal Chase bank account to seize over $30,000 from my account, not LLC account. There's a long list of allegations in this 69-page long second amended complaint, very well pleaded, and they state the claim of my personal injuries. And at this point, in the interest of the justice and in the interest of public policy, their motions to dismiss should be denied, because we need justice. This is not how justice is achieved. What I've faced firsthand, the deepest level of corruption, civil conspiracies between councils, aiding and abetting, and they did not even submit a scheduling order because they had no intention to even work. And they transferred title of my money to them by inducing false reliance on their statements. $25,000 retainers, $5,000 retainers, multiple replenishment, and not a single thing done, not a single thing. If anything, they made the case go against me because Escuda intentionally wanted to target me because I was the whistleblower. My patients submitted their statements that they almost nearly escaped death because of unsafe plaza condition. And City of Glendale, I have submitted their citations, civil and criminal citations. It took them 2 years to bring the plaza condition safe. I should have been focusing on my medical care, where in Arizona, the endocrinologist is in huge shortage. People are literally waiting for 9 to 12 months. And I told my staff I cannot take new patient. For 1 year, I did not take any new patient. Thank you.
Thank you, Ms. Carr. Anything further before I go over to the defendant counsels for rebuttal? Anything further before I go over to defendants?
Yes, coming back to Isle's talk, he said I told him that he cannot submit motions to dismiss. That was based on May minute entry by the court. The court made it very clear that every defendant has only 2 weeks to submit any motions. So he asked me just a couple of days ago, which was 2 months after the deadline. And I asked him, this is not the time. You passed your 2 weeks time frame, which was in the minute entry. So I told him, if he files motions to dismiss, I'll file motion to strike, because court gave him 2 weeks only, according to the minute entry.
Thank you. And that was really directed, as you know, the motions to dismiss that had been filed previous to your amending your complaint. So I couldn't prohibit someone from filing a responsive pleading.
No, if you look at your, it was after second amended complaint, the minute entry.
I understand. I may clarify that and allow, because I wouldn't prohibit somebody from filing a responsive pleading. You understand that, right?
Right. You gave them 2 weeks, but he asked for motion to dismiss to be filed 2 months later.
I understand, but I'm likely, I just want to telegraph, I'm likely to modify that, because I'm not legally permitted, as far as I know, from prohibiting somebody from filing a responsive pleading to a complaint. You understand that, right?
Absolutely.
Okay, very well. Thank you for that Anything further, Ms. Carr?
Not at this point.
Okay, thank you. I appreciate your time. And counsel, you have remaining time to rebut, and I think we can follow the same order. So we can start with Mr. York.
Your Honor, I don't have anything further to say. I trust the court's judgment. Thank you.
Thank you, Mr. York. Mr. Ailstock, I did want to follow up with you because I wanted to get a sense of, I don't want to rule on these motions to dismiss piecemeal. I wanted to understand the court is, as I understand it, is it's necessary for me to provide a responsive pleading, and you indicated, I think, that would be a motion to dismiss, but I wanted to get a sense of a timeline so that I can rule on all motions to dismiss at the same time.
That's correct, Your Honor. And so as I stated earlier, as I read the minute entries, I felt it was directed to the appearing defendants that hadn't yet appeared with the Rule 12 motion or responsive pleading because I'm watching the filings and reviewing everything. I will file a Rule 12 motion to dismiss next week. It'll be on file for you so that Ms. Carr could file a response. I will file a quick reply so that the court can rule on all the pending motions at the same time. And I will not request oral argument, Your Honor.
Very well, Ms. Carr, does that make sense to you?
Yes.
So that this can be fully briefed and the court can rule on all motions to dismiss at once?
Yes, Your Honor.
Okay, thank you, Ms. Carr. Thank you, Mr. Ailstock. Mr. Zazuta.
Yes, Your Honor, I'll be brief here, but I guess there's a lot of discussion regarding facts that are not pled in the complaint. So I was asked the court to disregard any extraneous facts and or allegations that are not pled in the four corners of the complaint. Going to the motion to strike, the difference between our exhibits and Ms. Carr's exhibits ours are matters of public record. So that's an exception to on the 12B6 motions, one of the delineated exceptions. I guess going back to the personal claims as a plaintiff alleges, so these claims are not pled with specificity, and that's the fraud. It's telling why the plaintiff keeps referring to they or defendants. So this is an impermissible group pleading when it comes to fraud. This is in our motion to dismiss, but so I won't belabor that point. And then as far as the civil conspiracy, there's no underlying tort or agreement that's pled for the conspiracy, which are fundamental elements of that claim. And lastly, Your Honor, it just sounds like the plaintiff is dissatisfied with legal strategy. If every person had the right to sue for abusive process or bring claims against their counsel for disagreements over legal strategy, our courts would be flooded with lawsuits just like this one, Your Honor. So for those reasons, we asked the court to strike the exhibits, strike the pages that exceed the allotted amount, and grant the motion to dismiss.
Thank you, counsel. Mr. DeSalles.
Thank you, Your Honor. Your Honor, what I didn't hear from Dr. Cower was my name. I heard a lot of theys, and I heard a lot of thems, and I heard a lot of what Mr. Zazueta described as group conspiracy allegations. I didn't hear a specific reference to me individually. And frankly, that's because the allegations against me can't be reconciled with the allegations against other people because they make no sense. The conspiracy, as far as what's planned, is I conspired with Ms. Doolin to, although I filed the motion that she wanted filed, that Dr. Cower wanted filed, that I somehow sat on it to result in it being denied for the purpose of keeping the case in a tier 1. I don't even understand the allegations or how that harmed anyone. I think it's wonderful that Dr. Cower is advancing her education by going to law school. Those aren't damages that stem from any cognizable claim or conspiracy. I hear allegations about churning a case for making fees. I was hired to file a motion. I filed that motion, and then a conflict arose because my client's contact, not my client, my client was the LLC, but Dr. Cower began filing documents that was inconsistent with my representation. That's a conflict. All that's a matter of record. So when we talk about the rise in foreclosures and she talks about the corruption and the allegations of churning a case, all those are just allegations, none of which are in the complaint. So there's not a single allegation that supports a claim against me. I would ask that it be dismissed.
May I
Thank
clarify?
you.
Thank you, Mr. DeSalles. I need to, this is the defendant's time to talk. Ms. Doolin.
Oh, thank you, Your Honor. As I was listening to Dr. Carr, what I was hearing is that she kept saying that they were her personal claims, but kept alleging that actions that occurred against the LLC. It's her. She has an LLC, and the LLC is the owner of the condominium in Escuda. So any claims against Escuda are the LLC claims. They're not Ms. Carr's claims. She has failed to allege any allegation against or any facts against herself. They're all legal conclusions. She keeps saying, there was a collusion, but there's no facts to back that up. There's no facts pled that money was stolen, but there's no facts to back that up. And as a matter of fact, the court and the one that Ms. Carr just decided actually struck those allegations from the record of this alleged embezzlement. There's just no facts in this case. It's just all conclusions, and it's all related to the LLC. Even this new allegation that she brought up today, that I somehow made up false documents to file with the court regarding a garnishment that was directed at the LLC. Anybody looking in the court docket can see that the writ of garnishment was directed directly to the LLC. So those are just false statements. Those allegations aren't in the complaint. And for those reasons, I'd ask the court to dismiss the case with prejudice. I join Mr. Zazetta in letting the court know that any future amendments would be futile because every allegation that she's alleged is against her LLC. Thank you, Your Honor.
Thank you, counsel. Ms. Jankaitis.
Thank you, Your Honor. Real quickly, I just wanted to remind the court about some legal points that have already been made, but just to reiterate, for example, the court's gatekeeping function when evaluating the sufficiency of an intentional infliction of emotional distress claim. That is a very high standard, and the court is empowered to make a determination from the get-go whether the allegations are sufficient for a jury to conclude that the conduct alleged was sufficiently outrageous. As to these defendants, the allegation is that the plaintiff didn't like the advice that she was given, or that they were negligent in not following instructions. These are not things, these are things that happen all the time. Negligence, ordinary negligence, is not sufficient to sustain an IIED claim. And it's not the type of conduct that is intolerable in a civilized society. With regard to the fraud claim, I think that it's been established that the LLC here is the client of the attorneys that are being sued here. This plaintiff was not the client. She did not have any right to rely on any conduct or statements that were made. And that's an essential element of fraud. That's not pled in the complaint and could not be amended to be cured because there is no right to rely. And then with regard to the abuse of process, obviously an essential element of that is the use of a process itself. And merely filing a lawsuit or taking action within a claim is not using a judicial process. The allegations are discontent with arguments that were made, legal strategy, things that were filed, the timing of when they're filed. None of that is use of a judicial process, let alone abuse of a judicial process that could sustain that claim to the extent that there are any personal to plaintiff that are alleged. I'm going to join in everyone else's arguments and ask the court again to dismiss with prejudice.
Thank you, counsel. Anything further from the defendants? Hearing nothing, Ms. Cower asked for an opportunity to, would clarify something, and I want to provide that opportunity, and then I'll allow the defendants the last word on that statement. Go ahead, Ms. Carr.
So their statement that I was not their client is wrong. Clients can be by conduct or by agreement. All these defendants communicated with me as Jasjeet Kaur as client. They invoiced me as Jasjeet Kaur as client, and their agreements were also with Jasjeet Kaur. So that has been already supported by case law that I was their client. So them saying that fraud was not committed on me because I was not their client is totally wrong. They used my name in their invoices. They used my name repeatedly saying Jasjeet Kaur is client. We spoke with our client Jasjeet Kaur. we communicated this thing with our client, Jasjeet Kaur. So I was their client. So them trying to make that statement that I was not even their client is totally false. And coming back to Mr. DeSala's statement that I did not speak his name. So I'm not sure. There are 6 pages of allegations listed against him in the second amended complaint under Roman numeral number 6, section D. So if he wants me to read those 6 pages, I would be happy to do so. So all these are facts that are already in the docket in the underlying action. So these well-pleaded allegations are factual allegations, and all those facts and evidence is already in the docket in this court in the underlying action. So nothing is made up. They are factual allegations, and they support fraud. They support I was their client. It supports intentional infliction of emotional distress. For exact same reason, the same court in the parallel case did find intentional infliction of emotional distress bar has been met. In fact, the underlying case that I cited, State Farm v. Campbell, in that case, the Campbell was asked to sell his house to fulfill the judgment, and State Farm told him wrongfully that he has to sell his house. He lost his sleep just for a few days because he was under the impression just for a few days that he has to sell his house to fulfill the judgment. That fear itself was big enough that the jury awarded $150 million award for that distress. I lived in that distress and emotional pain for 10 months that my medical office condominium can be foreclosed. And Doolan did not even notify my counsel at that time that she has filed a foreclosure claim of my medical office condominium. We found out right before it was at the brink of default judgment because she asked for default judgment to foreclose my property without telling me, without telling my counsel. First time I found that out through my counsel was January 5th of 2024. Since then, I have been monitoring docket every day myself because I literally missed the default foreclosure claim against my property by a matter of days. And it stayed in place for 10 months. And it's still a threat on my mind. So I'm under constant emotional pain and suffering. And they are saying it does not meet the bar for intentional infliction of emotional distress is totally wrong. And the same court has already said in that case, it has survived motion to dismiss because it definitely meets any bar for emotional distress. It's beyond any bounds of decency in a civilized society to fabricate a foreclosure claim of somebody's property to try to harass them and try to distress them so that they can suppress them from doing what they're doing, which is whistleblowing against them. This is intentional. This is extreme and outrageous conduct that they have inflicted on me. And my own counsel did not bring any relief for me at all. So these claims are my personal claims. On top of that, Arizona law recognizes both actions by LLC members for their own rights and interests and derivatives to enforce rights belonging to the LLC. See Arizona Revised Statutes Section 29-3808 and Arizona Revised Statutes Section 29-3803 and Arizona Business and Commercial Law Section 5.08, 2026. Arizona authority further recognized that at any stage of a direct or derivative proceeding, the court may, in its discretion, treat a direct action as derivative or a derivative action as direct. And these are my direct personal claims. And I have listed a huge list of LLC claims, which I'm not bringing. These are my emotional claims that only a normal biological human being can suffer, and they inflicted on me intentionally. And on one hand, there's also supremacy clause. On one hand, if the court treats LLC as a human being, then court should also acknowledge that there's a section, Article 6, Section 2, Clause 2, supremacy clause, which means the constitutional rights are the supreme law of the land. So denying motions to dismiss would serve that purpose.
Thank you very much for that, Ms. Carr. And as the defendants of the moving parties, they get the last word. I wanted to hear if there's anything else based upon those comments.
Your Honor, since those seemed mostly directed at my arguments, I would just like to point out the obvious fact that that was far more than just a clarification of a point, and that, as everyone has repeatedly said, the allegations of the complaint do not state a claim because they are too general. They don't put the defendants on notice of what's going on. The legal arguments I made are simply highlights for the court to consider. Thank you.
Thank you very much. Anything further from any of the defendants?
Your Honor, I'll be quick here on just the point about another court hearing, another court ruling that she has a viable IAED claim. There's no preclusive effect to argue otherwise in this case, and the court is not bound by another judge's decision for an unrelated matter. And that's all on that point.
Thank you. Anything further from the defendants?
No, Your Honor.
Yes, Your Honor. I just wish to point out, Ms. Carr said repeatedly that all the defendants represented her. Our firm, or Mr. Travis and I, never represented the LLC or Ms. Carr. We represented Escuda Condominium Association in defending it against the lawsuit that the LLC brought, and also in filing a breach of contract claim against the LLC. So our firm has never represented Dr. Carr. She also alleges today that somehow, I fabricated a foreclosure lawsuit, and that it was on the brink of default, that I had filed a default judgment before she even learned about it. And the court record shows that is an absolutely false statement, that her counsel actually filed an answer to the counterclaim before it was even served upon them. So there can be no default when the file has not even been served. So I just reiterate what we've spoken about, Your Honor, and again, what my co-counsels have said. All these claims are claims of the LLC against the condominium complex, that they're not individual claims of her, and I'd urge the court to dismiss the case with prejudice.
Thank you. Anything further from defendants counsel?
No, Your Honor.
Your Honor,
Yes.
I would just like to add that in hearing what Ms. Carr had to say, she still, in any case, has not enunciated a coherent cause of action, whether for herself or for her LLC. It's just there isn't a coherent cause of action. And I'm concluding saying with what I began saying, and it seems to have held true throughout this hearing. So that's my comment, Your Honor.
Thank you. Anything further from defendants counsel?
Nothing further from me, Your Honor.
Nothing further, Your Honor.
Nothing
All right.
further, Your Honor.
Well, thank you very much to plaintiff and defendants counsel for your time and for your efforts and for providing your positions in this matter. The court understands that there is one motion to dismiss that needs to be briefed, and it's going to be, and that motion to dismiss is going to be filed by no later than next Friday. Is that correct, Mr. Elstock?
Yes, Your Honor.
And that will be responded to timely by the plaintiff, and a reply will be timely filed. And then once that is fully briefed, the court will take all the motions to dismiss under advisement and will issue a ruling. Anything else before we adjourn?
No, thank you, Your Honor.
Anything? I'll ask the plaintiff first. Anything before we adjourn?
There are factual allegations against each defendant enumerated multiple pages, so they keep on saying there's no factual allegation is false.
Thank you. Anything further procedurally?
Thank you.
Okay, thank you. And anything further from the defendants before we adjourn?
No, Your Honor.
No, Your
No,
Honor.
Your Honor.
All right, thank you again. And again, the court will, once the outstanding motion to dismiss is to be filed by no later than August 14th is filed and fully briefed, the court will take that matter under advisement, and will take all these matters under advisement, and will issue a ruling on all of the motions to dismiss in addition to the motions to strike. And thank you again for your time and for your efforts, and this matter is adjourned.
Thank you.
Good morning.
And Ms. Sweeney, if you could state your name for the record.
Good morning, Your Honor. Erin Sweeney, and I am counsel for myself.
Thank you, and good morning. And we are here today on a return hearing. A complaint was filed on the 29th of July, and a ruling was issued granting a temporary restraining order pertaining to the foreclosure sale of a property located at 170 East Guadalupe Road, number 12, Gilbert, Arizona 85234. This return hearing was set, and a bond of $1,000 was set. The court wanted to talk about next steps in this matter, whether the parties have reached any agreements.
Yes, I agree.
Go ahead, Mr. Ambar, if you can bring the court up to speed, and then I'll hear from Ms. McQueen, and then I'll hear from Ms. Sweeney.
Okay, yeah, I agree for the bond of $1,000. I'm right now at the courthouse, but the time ran out before I put in the bond.
But you're planning on filing the bond today, or
Yes.
securing the bond today? Okay.
Yes.
Anything further regarding the sale of I know that the sale of the home and reviewing the documents listed August 5th as the sale date. Did that sale proceed, or did it? What was the current status of the home?
The current status of the home is it hasn't been sold. According to the restraining order and the stop order by the judge. And as of right now, we would like to get all discoveries and authorities regarding the property from Ms. Sweeney and be ruled in this court for the court to rule the rights and the authority in which she's trying to sell the property. Because we purchased the property already from the sheriff on behalf of the person she's suing. The first owner, his name is Miguel Flores, and I found the information about the property going on sale while I was cleaning the property. I found it in the trash in the house that we purchased.
Thank you, Mr. Ambar. Ms. McQueen, anything to add or amend to that?
Nope, George Ambar, he included everything.
Thank you, Ms. McQueen. Ms. Sweeney, I wanted to hear from your perspective.
Yes, Your Honor. First, I wanted to address the trustee sale that was supposed to occur on August 5th. The lender, I am the foreclosure trustee. I am not the lender. The lender chose to cancel the trustee sale to proceed judicially. So there currently is no set trustee sale at this time. They are planning to file a judicial foreclosure action that has not been done yet. As far as the background of this matter, the property was previously sold at a sheriff's sale to Mr. Ambar after a lien foreclosure. That lien was junior to the mortgage. Therefore, that sale did not extinguish the mortgage on the property as a senior lien. So the lender is still planning to proceed with foreclosure at this time as the borrower is still in default.
Thank you. And I heard Mr. Ambar's request for discovery in this matter. What is your proposal regarding next steps?
Your Honor, instead of filing an answer, I plan to file a motion to dismiss.
Thank you for that. And what's the timeline on that?
Your Honor, I'm currently out of the office. I will not be back in the office until Monday, but I could have a motion filed to the court next week.
Very well. So is it your view that a period of time on the dismissal calendar would be appropriate while this matter is pending? What's that? Yes.
Yes.
Okay. So, Mr. Ambar, the dismissal calendar is a period of time that the court provides the parties. It's basically a deadline by which, unless something happens in the case, then the matter may be dismissed. It sounds like there's going to be a motion to dismiss filed by Ms. Sweeney next week. You'll have an opportunity to respond to that motion to dismiss. And then Ms. Sweeney will have a chance to reply in support of her motion to dismiss. The court would then need to rule on that motion. Would it be appropriate to set the matter on the dismissal calendar for 60 days so that that motion can be briefed and so that any other matters can be, so that additional work can be performed on the case?
Absolutely, Your Honor.
Okay.
Yes, Your Honor. One additional fact, I apologize.
Yes.
I believe Mr. Ambar has been trying to serve my office. I'm currently out of state.
I believe his process server indicated he would return on Monday when I'm back in office, and I will accept service at that time. So that motion is pending service of the complaint and summons.
Okay, so Mr. Ambar, it sounds like that service will be accepted by Ms. Sweeney upon her return in the office on Monday. Is that makes sense on your end?
Yeah, that makes sense.
So the court's going to set the matter on the dismissal calendar for Friday, October the 9th, in order to allow the parties time to brief the motion to dismiss. Mr. Ambar, as I understand today, will post that bond, so that I don't think that will be an issue, and to allow for Ms. Sweeney to be served on Monday, and for the court to review and set any next steps on the motion to dismiss.
Thank you, Your Honor.
At this time, the court is not going to disturb what was ordered as far as the temporary restraining order in this matter, but will consider the motion to dismiss and any next steps. Is there anything else that the court can assist the parties with at this time?
Your Honor, I don't believe if there is no trustee sale set, and we have yet to file a complaint for judicial foreclosure, if there's need for a temporary restraining order at this time, so that Mr. Ambar does not have to give a $1,000 bond if it's not necessary.
So is there an agreement? I think what is being proposed, as I understand it by you, Ms. Sweeney, is that there's an agreement that there will not be a foreclosure sale. Therefore, the posture of the temporary restraining order would not be necessary. The bond would not be necessary. And the court would, the next step for the court to consider would be a preliminary injunction hearing or a final orders hearing.